So last point, you know, I actually, you suggested, Alan, that, well, if the agency has come lately to it, then maybe, you know, we should give the agency less deference. I actually think, in at least my practical experience, the agency, at least FDA, got a lot more deference, and I'd be interested in your views on whether it should, when it came in on a case-by-case basis and said, we have looked at the specific question, and in this case, we believe there should be preemption. Most of those cases, when the FDA got involved, on a targeted case-by-case basis, the federal courts ended up, or in one case, the California Supreme Court, ended up giving the agency deference. It was when the strategy was tried, and by the way, the Pre-Emption preamble came out in 2006. I left in 2004. When the Pre-Emption preamble came out, that was an attempt to, instead of go on a case-by-case basis, which is very resource-intensive, to deal with it in a broader way, and we know what the fate of that was in Wyeth versus Levine. So I guess I'd be interested in your views. I mean, it would seem to me that if the agency's made a specific decision in a specific case and explains why in a particular case they think their ox is gored by the state regime, I would think that would get more deference, not less.
Well, I think the problem is that it looks, especially when they come in at the very end of the case, like they're results-oriented in the case. And the early aspect is explaining what they're doing and why they're doing it at the beginning to indicate, as in the tampon labeling case, for example, that more is not necessarily better. And it seems to me that's the problem, that you have them coming in and saying, well, take Geyer, for example. I would have had no trouble with the outcome in Geyer if the agency had thought about preemption back then and said, you know, we don't want anybody to force anybody to do it. This is an important, if they had said even in the rule, instead of making it up 25 years after the fact, that the reason we gave people an option was because we wanted compliance and all the things they ultimately said in the Supreme Court, which they completely made up. I think they should have to say it at the time they make the decision, whether they use the preemption magic words or not, but the rationale at least has to be there. And then you don't think that they're deciding it based on who they want to win a particular case.
Yeah, I do think, though, that, I mean, I agree with Dan that the case-by-case intervention, at least empirically, seems to hold forward. Particularly, actually, this is where I think there also is a difference between state versus federal court. So FDA more likely on its own to intervene in federal court versus state court. Also, federal courts more likely to call for the views of the federal agency versus state courts. Federal courts are more used to seeing federal agencies before them in a whole host of issues. Informally, various judges have also confirmed this kind of difference that comes out empirically in the cases. I think that's a slightly, and maybe you two are talking now past each other, I think it's a slightly different question with respect to when in that case-by-case intervention, when the court is reviewing what the agency is saying, what is it based on? Is the agency just coming up with some quote-unquote litigating position, or can they show a regulatory record to say this is a risk that we really looked into, et cetera? Very interesting to me post-Wyeth case to look out for in the SSRI antidepressant. Colachico, it had been in the Third Circuit, got remanded after Wyeth. The U.S. Government withdrew its position. They had submitted an amicus brief in favor of preemption before. I think the withdrawal, this is speculative, the withdrawal of the U.S. position is part of what made the Third Circuit just remand it back down to the district court to go back, let's do this again. I think that the position of the United States, the FDA, in that kind of case, on how closely they were looking at the risks in the SSRI context would be very, very important.
Yeah, and that is one of our cases. That is a GSK case. And just to be, I mean, again, the tension is the agency makes this decision not in a formal rulemaking context. The reviewers make these decisions on a day-by-day basis. Then there's the litigation, and the question is, at what point should I mean, I guess I'm struggling with at what point does the agency need to get involved in order to get this level of deference? By definition, if it's getting involved after the litigation has commenced, then you could, Alan, accuse it of picking winners and losers. But before the litigation, there isn't really a preemptive action to take. Now, the SSRI cases that Kathy mentions, the FDA, time and time again, including in public fora and in the rejection of citizen petitions, including some by public citizen, said, we do not believe you should have a suicidality warning on these antidepressants. And the argument was that the the agency is, to use the language of Chevron, directly spoken to the precise question at issue, and when that is true, there should be preemption. The Third Circuit had said yes. Post Wyeth, I guess we're at a fresh start.
One question, and then we're going to start inviting questions from the audience. There is a microphone in the center of the room. I'm stunned that Roger Pilon is the first to approach it.
I'll try not to disappoint.
But I will ask that those who approach it have a question in mind, as opposed to speech. But the question I was going to ask first of Dean Morrison is that you mentioned that federal courts of appeals are, in your experience, more likely to favor preemption than the Supreme Court. Do you have maybe I have a personal interest in this. Do you have an explanation for that? And could it be that the reason is just the mix of cases that the federal courts of appeals are more likely to see, which I guess are more likely to actually involve the agency as a litigant, whereas the Supreme Court is exercising jurisdiction over cases not only from the federal courts of appeals where agencies are involved, but from state Supreme Courts and from the state tort system, and therefore it's just the result of a different mix of cases, or is there some other explanation?
Well, I actually probably should have qualified my statement because I haven't looked at it in the last few years. Certainly it was very true in the tobacco area where state courts rarely found the kind of preemption, or they found some sort of mixed preemption, and in tobacco the federal courts were essentially unanimous in finding total complete preemption based upon a statute which was fairly broad but not that broad. I think one of the explanations may be that what happens in these cases, and most of them are tort cases, is they're handled by lawyers who are basically product liability lawyers, who are not used to interplay of federal preemption law and federal agency law. And when they get to the Supreme Court, other people get brought in who are more familiar with them, and they turn the case around in ways that just didn't happen. So I think that's part of the explanation, and I don't have anything more to say than that on it.
Yeah, Dr. Greve, you have a thought about this?
Yeah, we've tried to look at it or thought about looking at it and done some preliminary work. It's just very, very hard to do because the universe of appellate cases about preemption is A, very large, and B, very hard to sort of circumscribe and define. My impression from sort of just eyeballing this stuff is that Alan is probably right. Your impression. And the other thing is that I would just warn against the inference from that the appellate courts are reflexively more pro-preemption. I think it's much more likely that the answer lies in the dynamics at the Supreme Court, the pattern of cert grants, and the factors that Alan mentioned.
So I take it, Alan, then you're on the side of Paul Clement with his recent exchange with Chief Justice Roberts, that advocates make more of a difference in the cases there than maybe the judges.
I think that's a pretty broad statement.
Rhetorical question.
There is another factor. My difficulty in getting these any kind of empirical data is, of course, the Supreme Court. You have 9 justices, and even those are shifting. In the courts of appeals, you have ever-shifting panels and multiple panelists, and so it's even harder to get any statistically significant numbers out of that.